Hey, another ditty about denials that you'll find in your determination letter where they disapproved your claim on initial or reconsideration. This one's not uncommon. Sometimes it's mixed in with some other jargon. So this person asked me, what about when the decision or the determination says your medical records suggest you have some work limitations, but not enough to stop you from going back to work, age, education, experience, blah, blah, blah. Okay, so what this suggests to me, and this is really, really common, and again, in and of itself, not a reason not to appeal. This would most likely be part of a decision, a determination for an under 50 claimant. And here the SSA is saying, yeah, we recognize you have impairments and that it limits some of the work out there, but it doesn't eliminate all those jobs. So there are other jobs you can do outside of the ones that you can't do. And with that reference to age, experience, etc., that's the vocational profile they're alluding to. So if you have something like that and you have absolutely no clue on whether it's appealable, it doesn't never hurt you to appeal. However, you might also, if you can, now obviously if you can get someone to look at your file with you and have you answer certain questions, you're going to get a much better, clearer picture on the strength of what you might have going forward. But if you didn't treat for every single impairment, and this is my recommendation, all lawyers are different, even those small ones, but you are willing to do it going forward, that might be a great reason to appeal because your evidence is going to change. It's going to start including more impairments that you might not think are huge, but that will carve out additional occupations from the occupational base, if you will, 12,000, 13,000 occupations. So that's one thing. If you've not gone and gotten all the diagnostics that were recommended, maybe you have trouble with insurance, that's something you're going to want to pursue. Have your doctor maybe appeal the insurance decision. If you fail to do a single piece of medical advice, such as physical therapy or considering injections, even surgery, although to a far less degree would anyone expect someone to have to do surgery if they're concerned about that. But all the things that are recommended to you, and each one that you choose not to do sometimes tells a picture as to how not serious of an impairment it is. Sometimes people aren't aware that they were even recommended to do it. And I always find it interesting because I'll see it in the medical record. And when I speak to the client, they're like, he never told me to do that. And of course, they didn't read their records. People don't just don't tend to do that. They tend to listen to their doctor while they're in the office. Something you might want to do if you're pro se and you don't have someone to do this for you, consistently get your records, order them officially. You may not get the whole boot in the portal that you might have. Although now they put up progress notes thanks to a law from a few years ago where they have to put up their progress notes. And that can give you a lot of the detail. But you'll see if there are recommendations, and then you'll see, oh my God, I didn't even know about that, and I didn't follow up in that way. I didn't pursue whether it's sending you to a consult with a specialist. Sometimes that'll be in the record, and I'll say, did you go to that neurologist that they refer? No, I didn't. And I'm like, so again, all those little attendant circumstances of not following up with things that you're told that would help your situation only paints a picture of someone without a serious situation. It doesn't really bother you that much. So I'd look to those things, what you haven't done that you might be able to do on appeal. And of course, if you've gotten that determination letter, ideally, you're going to get a professional, an attorney or non-attorney rep on board before you appeal the next appeal, so they can make sure it's done right. Obviously the initial done so far wasn't done so great. And that also gives them more time to review and give you the advice that I'm kind of blanket laying out there now that's not specific to any kind of particular claim or person, but that professional can direct you specifically based on what treatment you've had and what complaints you say you have. Okay, so very common denial, not a reason to not appeal, but if you want to appeal successfully, you're going to want to start addressing what you haven't done thus far in your case. Sometimes that means starting over is the best avenue, but that's a very detailed analysis as to whether that would be best or not. So do your due diligence. Okay. Have a great one. Bye.